Welcome back to the channel. If you've been following the Johnny Depp and Amber Heard trial, you've probably seen some clips where Depp's attorney is objecting to almost everything that Amber Heard has been saying in her testimony. So I thought it might be interesting to give you some commentary and some explanations as to why these objections are happening, so you can understand what's happening, why they're being objected to, and why it interrupts the flow of her evidence. So you'll hear terms such as hearsay, which is something that is not said in oral evidence, but is intended to prove the truth of the matter. You might hear terms such as calls for speculation, because speculation in and of itself is not evidence. Very often you might hear the objection leading, which is where the answer is suggested in the question itself, because the evidence is supposed to be of the witness themselves and it's not supposed to be suggested by counsel. So let's watch the clip and you'll see what I mean as they unfold.
It has been suggested by Ms. Vasquez to you in your questions that you didn't tell anyone about the abuse until the TRO. Is that true?
Objection, Your Honor. Leading.
You can see the first one right off the bat. There's an objection because it's leading, because the question is suggesting the answer.
All right. What if any? All right. Who did you tell about the abuse during the time it was happening?
Objection, Your Honor. Leading.
That's not offered to.
And hearsay.
So this one is leading because to say, who did you tell about the abuse? Well, to suggest that the abuse happened at all is a leading statement. So who did you tell about the abuse? It's a bit like me saying, who did you tell about the car crash? It suggests that the car crash happened. If the fact that the car crash happened is disputed, then the fact that that is mentioned in the question is a leading question. And the second part of that, who did you tell about it? There's a hearsay portion to that as well, because anything from anyone else is not going to be in oral evidence. Let's keep watching.
Sustained.
Your Honor, it's prior consistent statements.
It's leading. It's sustained. Next question.
Okay.
So you can hear there the judge mainly sustained that objection, meaning that question was not permitted, mainly based on the fact that it was leading. Let's carry on.
What, if anything, did you tell to anyone about the abuse?
Objection, Your Honor. Hearsay.
I'll sustain.
Your Honor, may I approach him?
That's fine.
So now Heard's attorney wants to approach the bench because she's obviously upset that her questions are not getting through. And so now while they approach the bench, there's a long period of silence because it's legal arguments. Ordinarily in the UK, they would, if it was a jury, they would send the jury out. Obviously, we only have juries in criminal trials, not in civil trials. But in the United States, of course, they have juries in a civil trial. So all of this portion is silent because the jury is not supposed to hear it. Much like a criminal trial in England and Wales, the judge would send the jury out of court so they don't hear the legal arguments. So let's skip forward this silent part and we'll get back to more of the questions.
Ms. Heard, how many people have you shared the fact of abuse prior to 2015?
Objection, Your Honor. Leading. Calls for hearsay.
How many?
Overruled.
So here it's been overruled because she's simplifying the question by saying, how many people have you told about it? So it isn't necessarily seeking to prove the truth of the matter, it's just asking for how many people that she's told. So it's a much simpler question.
Roughly about 10.
Okay. Can you name them?
Yes.
Objection, Your Honor. Hearsay.
I think she can. It's not offered. It's just to show that she informed people before. They're suggesting.
Objection, Your Honor. Can we approach? This is, again, an approach.
So now again there's an objection on the basis of hearsay because it's going to be information from someone who is not here giving oral evidence, and hearsay is anything that is to prove the truth of the matter, cause a person to believe or a machine to believe or operate on the basis that the fact of the matter is true. And since they are not in court, Depp's attorney is objecting once again and has asked to approach the bench once again. So now there's another long period of silence whilst they have their discussions with the judge and get back to questions.
You were asked whether you had consulted a medical doctor about any problems with your nose, correct?
That's correct.
And you indicated that you in fact had after the divorce,
Objection,
correct?
leading.
Did you or did you not consult an ENT after the divorce?
Objection leading.
So again, leading objections because the question is suggesting the answer. There would be a much more open way to ask this question. Open questions generally who, what, where, when, why, how, but without suggesting the answer to the question within the question itself.
Did you produce medical records to the defendants relating to this?
Objection leading
All right,
calls.
I'll sustain the objection.
Thank you.
It's leading.
And-
Next
and
question.
Your Honor,
And
we
once
could-
again,
witness could be instructed
the answer
not
is
to
suggested within the
answer
question,
until
so it's
I
objected
lodge my
again.
objection. Witness could be instructed.
Could we bring up Defendant's Exhibit 1077? Do you recognize this document?
My screen is black. Oh, sorry. Wait. Yes, I do.
And could you tell us what it is?
That's the what my ENT, the ears, nose, and throat doctor, told me was.
Objection, Your Honor. Hearsay.
All right, when there's objection, please stop talking. Thank you. All right, I'll sustain the objection as to hearsay.
Okay.
Again, this is information coming from a third-party source, which is not in oral evidence, and if it comes out in Amber's evidence, then it's seeking to prove the truth of what she's saying. Therefore, it's hearsay. Therefore, Depp's attorney has objected to it, and it's been sustained once again.
What, if any, you were asked if you had, it was suggested that you had not produced this in discovery. Is that true or false?
Objection, Your Honor. Leading.
Your Honor, she absolutely did that.
It's leading. It's leading question, though. I'll sustain the objection as to leading.
Again, this is a leading question. It's been suggested that you did not produce this document in discovery. That's suggesting the answer to the question and eliciting her agreement with that question. So it's a leading question.
What, if anything, did you do to produce medical records to the defendant, to the plaintiff in this case?
I turned over all of my devices, and they had Johnny's team had a third party or someone they selected as a third party go and pull all relevant documents from those devices, which I handed over.
Do you know how many were handed over?
Hundreds of thousands, I believe. Maybe.
Objection,
many
Your
more.
Honor. Lack of foundation.
All right, I'll sustain the objection. Next question.
A lack of foundation is simply when there isn't evidence to support what she's saying. So she's trying to say something as evidence, but there isn't any evidence other than what she says about it. So she's saying in evidence now that there were hundreds of thousands of documents. However, there isn't any foundation for it. This is just her saying it in evidence and wants it to be evidence that there were hundreds of thousands of documents. But there isn't any basis to say that there were that many documents. Hence the objection for lack of foundation, which is sustained by the judge.
All right, I'll sustain the objection. Next question.
And what, if anything, did you produce to the plaintiff in connection with your consultation with an ENT specialist relating to your nose?
Objection. Leading.
Sustained.
Foundation. Hearsay.
What, if anything, is not the cure-all? It's sustained.
So there's a combination of objections, leading because it's suggesting the answer for what she wants her to say. So it's a very, very specific question. Although it starts with what, if anything, they both know precisely what they're going to be referring to. Therefore, the overall question in its construction is leading. Lack of foundation because she's going to refer to something that there won't be evidence of because it's just coming out in her oral evidence, which it should be in other evidence if that's what they want to rely on. And again, hearsay because it's going to be something other than oral evidence that's trying to prove the truth of the matter stated.
When did you see an ENT specialist?
2017 or 2016 or 17.
And as a result of that consultation, what did you learn about your nose?
Objection, Your Honor. Hearsay.
I'm not asking her to tell what they said.
No, I'll sustain the objection.
So again with the hearsay because she's inviting her to comment on some third-party information which will seek to prove the truth of the matter that she's trying to bring out, and hence it's hearsay. And again, it's sustained.
What, if any, production did you make to the plaintiffs of your medical records with the ENT?
Objection, Your Honor. Lack of foundation.
If you only have foundation.
Do you know whether the records, medical records, from your EMT were produced in discovery in this
Objection,
case?
Your Honor. Lack of foundation calls for speculation.
I'm asking.
Overruled if she knows.
Thank you.
Yes.
Okay. And do you recall? I'm trying. What, if anything, did the medical records reflect about your nose?
Objection, Your Honor. Hearsay.
I'll sustain the objection.
See, again, hearsay, because she's asking what, if anything, even though it's a what, if anything type question, whatever the information is going to be a third-party source of information. She didn't write it, she didn't create it, therefore it's third-party, and if she brings it out in evidence, it's seeking to prove the truth of whatever it says, therefore it's hearsay, therefore the objection was sustained.
Do you have injuries to your nose?
Yes.
Please describe those to the jury.
I have a bunch of scar tissue.
I'm going to object to the extent it calls for hearsay and lack of foundation
Overruled.
and improper expert opinion.
Well,
She can certainly testify too.
we'll see where it goes. Go ahead.
Okay, go ahead.
So here the judge has allowed her to continue because she's just asked her about the injuries to her nose. The objection on the basis of calls for hearsay is because it's likely to rely on what those documents say, which in and of themselves are hearsay. Calls for speculation. You can't just guess at something because that isn't real evidence. But the judge did allow her to continue to see where it goes. So the judge will probably step in if she steps over a line and starts to refer to documents and, you know, the documents told me X, Y, or Z, the judge will probably step in.
Go ahead.
I have a significant amount of scar tissue in my nose.
Objection, Your Honor.
I'll sustain the objection.
So the objection here is clearly because that information came from those documents. She wouldn't necessarily know herself whether she had scar tissue or not in her nose. It's most likely has come from those medical reports, which, as we said earlier, is hearsay.
What, if any, difficulty do you have breathing?
Objection, leading.
What, if anything? And that does cure on
No,
it.
it doesn't. But I'll overrule the objection.
Thank you. Do you remember the question?
I have a significant amount of trouble breathing at night, and I've been putting off having surgery for it.
Okay. Now, you were asked about December 15, 2015, and Ms. Vasquez suggested that you did not report the abuse or the injuries to Aaron Falati. Do you recall that
Objection, Your
question?
Honor. Leading.
Your Honor, I'm entitled to go into what Ms. Vasquez asked.
The objection is
See,
leading.
again,
I'll sustain the
objection because of
objection.
leading, because again, the answer was suggested within the question.
Did you report, what, if anything, did you report to Aaron Falati about the abuse you sustained on 12/15/2015?
Objection, leading and hearsay.
Approach.
See, again, the fact mentioned of the abuse is suggesting the answer, and hearsay because it's calling for what someone else has said about it. And so, again, because of going around in circles, the judge is asked to approach the bench again for silent legal arguments. So hopefully that gives you some idea about what these objections are, why the objections are being made. On very few occasions, they're overruled and the judge allows Amber to answer the question, but mostly those questions were either leading or relying on hearsay or calling for speculation or a lack of foundation or any combination of those. So I hope you found that interesting. If you do, please like the video and subscribe, and I can do many more of these to give you some insight to these American cases. Thank you for watching.